Right, welcome everyone to this Law Society discussion and Q&A on pathways to a judicial career for aspiring solicitor judges. It's so good to see so many of you have joined us this evening. We would encourage you to make full use of the session by asking questions. Please type questions in the chat box. If you have any technical issues, please post these in the chat and one of our team will respond, or you can email learning@lawsociety.org.uk if you have any issues. To avoid any interference, we'd ask you to please ensure that your microphone is on mute throughout the session. If you do require any captions during the session, click the three dots that are next to your camera and microphone options and select Turn on Live Captions. Just to let you know that today's webinar will be recorded and the recording will be shared with all participants. We'll now get started and I'll hand over to Vicky Fox, who's the Chief Executive and Accounting Officer of the Supreme Court and JCPC.
Thank you very much, and a very warm welcome to everyone to this webinar, Pathways to a Judicial Career. It's being held in partnership between the Law Society and the UK Supreme Court. My name is Vicky Fox and I'm the CEO at the court. We have a large number of people attending today, and I know that some of you will be very familiar with the role of the court, but for those a little less familiar, the Supreme Court is the final court of appeal for arguable points of law of general public importance arising from civil cases throughout the UK and from criminal cases in England and Wales, Northern Ireland, and in a limited number of cases from Scotland. So this evening we're looking at how you can apply for the judiciary. And the purpose of the webinar is to gain an understanding of the role of a judge and why solicitors can and should apply for judicial roles, to learn about the selection process and to receive practical advice on navigating that process, and to hear firsthand about what it's like to have a judicial career. And having a judicial career can seem difficult or daunting, or perhaps not something you've thought about as a career path for you. And to want to enter the judiciary, a person has to see it as a world in which they can picture themselves belonging and flourishing. So it's important to have practical support, to have encouragement and a network or community to help you along the way. You might be wondering why the court is part of this webinar. That's because the court recognises that it has an important role to play in supporting and encouraging solicitors to consider joining the judiciary. And it's worth saying at the outset that the court and the Law Society are interested in attracting the very best people to become judges. The court is committed to ensuring that we have a more diverse judiciary, and we believe that attracting, developing and retaining a diverse judiciary is essential not only to the public that we serve, but to the judiciary itself. We've got an excellent panel of speakers tonight, and let me introduce you to chairing the session will be Lubna Shuda, the President of the Law Society of England and Wales, Lady Rose, Justice of the Supreme Court, Jane Furness, who is finishing her term of office at the Judicial Appointments Commission and has recently become a non-executive director at the Supreme Court, and Judge Mulready, who's a first-tier tribunal judge in the Immigration and Asylum Chamber. And here's what to expect this evening. So we will have opening remarks from all members of the panel, and then there'll be an opportunity for you to ask questions, and please feel free to ask any questions. And then there'll be closing remarks and the webinar will finish at 6:30. But before we hand over to our speakers, we'd actually like to hear from you. And that will help us understand who's at the webinar, and also what stage you're at, and the sort of things that you're concerned with. So here's the first question, and I think my colleague Stephen is going to set up the poll for everybody. So coming up on your screen should be the first question. Have you applied for judicial roles previously? This will not show your name. It will just show what of the audience who's applied and who hasn't. So if I can ask everyone just to click on an answer. And I hope everyone can see on the screens the answers coming up. And we can see, this is a test of my maths, isn't it? About half the audience haven't yet applied. And you can see that half have applied to either courts, tribunals, or both. Let's move on to the next question, which is, if you didn't apply, what was the main reason? What was holding you back? So again, Stephen, I'll hand over to you to set the poll up. Here we go. So I'll give everyone a few seconds to fill in those answers. And here we see the answers coming up. And can see that a significant number of people didn't think that they would be successful. And that's why it's so fantastic that you're on this webinar, because I'm sure that everyone on the panel will be able to convince you that that is not a good reason not to apply. And for those that didn't feel equipped or didn't know how they could become judges, this webinar is for you too. Right, let's move on to the final question before we get going. And here it is. And this is just for us to know who's in the audience, how many years PQE do you have? And again, I'll hand over to Stephen to run the poll for us. And there we go. So we can see about 3/4 of people have over 10 years PQE, but we have a fair number of people between 0 and 10 years as well. Thank you very much, everyone, for taking part in this. And without further ado, I'm going to hand over to your chair, Lubna Shuja.
Thank you very much, Vicky, and good afternoon, everybody. Thanks for joining today's event on Pathways to a Judicial Career. I'm really delighted that the Law Society has partnered with the Supreme Court on this very important event. And it was interesting seeing the results of that poll. I hope by the end of the session, we will have answered your questions. We will have given you some practical advice as you look to further your career as a judge, so that you won't feel that you don't have a chance of success or you don't feel ill-equipped. I'm particularly pleased to be chairing this panel. Many of you will know that judicial diversity has been a key focus of my presidential year, and it is an area that I feel quite strongly about. The judiciary benefits from a diverse bench, bringing a wide breadth of expertise and experience to our justice system. And to properly reflect the society that we serve, we need to make sure that the judges are chosen from the widest pool of talent possible, regardless of background. We know that the public like to see themselves reflected in those who are making decisions on their cases. We also know that judges have a range of transferable skills that are really well suited for judicial roles. So as the professional body for solicitors, the Law Society is really determined to advocate for greater diversity among the judiciary, including the appointment of more solicitors to the bench. We are running a number of diversity and inclusion activities, and through those, we are working to enhance the diversity of the profession and thereby the pool of candidates that would go forward and think about a judicial role. We're helping solicitors to apply for judicial roles by providing training, by providing support networks. We help to run the pre-application judicial education programme that supports talented lawyers from underrepresented groups to feel more equipped, more confident and more prepared when they are thinking about applying for a future judicial role. So it's really good to see that, you know, many of you who are on the webinar today you clearly have already expressed an interest in becoming a judge, which is why you're here. So that's really good to see. After today's Q&A, I would really like to encourage all of you to join the Law Society's Solicitor Judges Network. If you haven't done that already, it's very easy to join. You just go on the Law Society website. There's a section on the website that's called My Law Society. You just sign up under My Law Society, and then you can select the Solicitor Judges Network as one of the areas of your of interest that you have, as well as perhaps other areas of law and groups that you might be interested in. The Solicitor Judges Network in particular has over 1,000 members already. That includes aspiring judges, it includes sitting judges, and it includes retired judges as well. It's a really useful source of guidance for prospective judges. It offers opportunities to make really valuable connections with your peers and also with sitting solicitor judges. So, as I said, you can find out more information about that on our website, so please do take a look. OK, so I think we've already had an introduction to our panel. We have Judge Mulready, who is a salaried judge of the First Tier Tribunal Immigration and Asylum Chamber. We have Lady Justice Rose, Justice of the Supreme Court, and we have Jane Furness, Lay Commissioner at the Judicial Appointments Commission. And I think Vicky just gave that brief introduction again, so sorry for repeating it, but you know, they're great judges. They're all women as well. How many? Yes, I'm absolutely. We've got to put it out there again. They are all going to be sharing practical tips on applying for the judiciary and answering your questions. And I think they're going to say a little bit more about themselves before we go straight into the Q&A. So if I can turn first of all to Judge Mulready, if you'd like to share a little bit about your background, I'm sure everybody would be really interested to hear about that. Thank you.
Okay, thank you so much for inviting me to join this event, which I'm very pleased to support, and it's a real privilege to be here, especially with these other panelists. I'm definitely the junior partner in this operation, so it's very lovely to be here with them all. I'm going to tell you why I joined the legal profession and give you a very quick tour of my work since then. I became a solicitor, having been inspired to do so by Gareth Pearce, who I got to know as a child because my mum was involved in the campaign to free the Birmingham Six from prison, and Gareth was their solicitor. They were 6 Irish men who were wrongly convicted of an IRA terrorist attack, for which they spent 16 years in prison. And in 1991, their convictions were quashed, and I was at home with the brother and sister of one of the men when they were released, and we watched it on the news together. And I was 10 years old at the time, and I watched their very moving reactions. And I began to understand then the role that solicitors play in achieving justice, particularly for people who are from marginalised groups and people who, you know, feel that they've given up hope. So I decided there and then I basically wanted to be Gareth Pearce when I grew up, and things have turned out a little bit differently. I did go and work with her for a while at Bernberg Pearce, her law firm, and I loved it, particularly working to represent young people facing deportation from the UK, which gave me my first professional exposure to immigration law, which as the daughter of immigrants myself, had always been an interest. But I was working in legal aid and I had 3 young children and I was being paid £18,000 a year. And even in the olden days, when I was a newly qualified solicitor, that was not enough money to live on. Life was very stressful. So I left legal aid and I became Stephen Sedley's judicial assistant at the Court of Appeal, which was, I mean, such a privilege. And I learnt and continue to learn so much from him. I then ended up in the civil service working at the Foreign Office, which I also loved. I got to work at the UK mission to the UN in New York. I got to advise on counter-proliferation of nuclear weapons, on sanctions on North Korea, war crimes, diplomatic relations, and, you know, the most controversial, politically charged, legally complex issues that were facing the government at the time, and be part of the team that was working on those, which was really fantastic. But eventually I did want a new challenge. And so I applied to be a fee-paid judge initially so that I could continue to work at the Foreign Office for a while and do the judge work at the same time. I did that initially in the Mental Health Tribunal, then in the Special Educational Needs and Disability Tribunal, and now I'm a salaried judge in the Immigration and Asylum Chamber. So that is me.
Lovely, thank you so much. And Lady Rose, could we find out a little bit more about you and your background?
Thank you very much, Lubna. Yes, I'm also delighted to be on this panel. I think it's a very important topic that we're going to explore this afternoon. I started my legal career as a barrister in private practice in Gray's Inn, specialising in competition law, which was a very niche topic in those days. After 10 years in practice, I moved then into the government legal service as an advisory lawyer. And I was there for about 12 years. But the first posting I had was in the Treasury, working on financial services regulation. Then I moved to the Ministry of Defence. And then in the last 3 years, I was working in the Office of Counsel to the Speaker of the House of Commons. When I left practice, when I left private practice, my one regret really was, which was in 1995, was that at that time ruled out me ever becoming a judge, because at that time, as you know, all judges in the senior judiciary particularly were drawn from the senior echelons of the bar. But I was very fortunate that whilst I was in the government legal service, the whole recruitment process was revolutionised with the creation of the Judicial Appointments Commission, and then it became possible for me to apply to be a judge, because the pool of potential candidates was opened up to employed lawyers and to government legal service lawyers. So I moved. The job I had in the House of Commons was 3 days a week, and I applied also. My first post was a fee-paid post in the Competition Appeal Tribunal, therefore going back to the area that I'd specialised in. So I juggled those two roles for 3 years, and then I left the civil service, took on a number of other part-time fee-paid posts, and then I was sworn in as a High Court judge in May 2013, and was a judge in the Business and Property Courts for about 5 years. And then I was in the Court of Appeal for a couple of years, and in April 2021, I became a Justice of the Supreme Court.
And congratulations on that, Lady Rose. It's fantastic to see you there, and
Thank you.
Great, yeah, really great to see female representation there. So we're really, really delighted. And Jane Furness, perhaps we could hear a little bit about you and your background.
Yes, thanks, Lubna. And so I'm the one member of the panel, including Vicky, who isn't a lawyer. And that was a very conscious choice of mine, having spent 2 or 3 summers of my adolescence with my father's best friend, who was a country solicitor, and I just decided that wasn't what was going to be right for me. So I became a probation officer after university, and then since being a probation officer and becoming a chief probation officer after a number of years, I moved from the operational role into policy, so into the Home Office and what was then the Lord Chancellor's Department, advising on criminal justice policy. So I've spent my whole career in the public sector and in the justice world, mostly criminal justice, and moving through various public sector roles. I retired from full-time work 10 years ago when I'd finished 6 years as the chief exec of the Independent Police Complaints Commission, and have since then done a number of non-executive type roles, including I was for a period, Lubna, on the SRA board a while ago, but more recently being appointed as a lay commissioner at the Judicial Appointments Commission, and I'm just about to come to the end of my second term, so I will have been there for 6 years. And as Vicky said, very fortuitously from my point of view, the vacancy for a non-exec was advertised over the summer, and I applied and was absolutely delighted to be appointed. So as one door closes, again, another one is opening for me, and I'm very much looking forward to joining the Supreme Court. I've always loved that building, actually, even when it was the very dark and rather grim Middlesex Guildhall. That's my background, and what I can talk about this evening is based on 6 years of seeing candidates for judicial office, and running quite a large number of both small and large outreach events, encouraging people to apply to be judges, and particularly encouraging women, minority ethnic people, solicitors, people in the CPS, people in the government legal service, who might think, like, half our poll did, that they wouldn't be successful if they applied because they haven't got the necessary skills. So I can talk a bit about that and what solicitors in particular need to do to be successful candidates.
Thank you very much, and congratulations to you as well on your new role. Look forward to seeing how that goes. Really, really excellent. So let's get into some of the weeds of what we want to talk about today, because we want people to be able to leave today with some real kind of action points and tips, and learn from the experience that all of you have had as to how they can put their best foot forward when it comes to them, applying for judicial roles. And one of the things that I know I've talked about a great deal, because I speak to kind of senior members of the judiciary and various other stakeholders about solicitors having transferable skills, because quite often, some of the things that solicitors say to me are, well, just because we're not in court, just because we're not litigating, just because, how do we prove that we can be really, really good judges? And, I think that's a real stumbling block when solicitors are looking at what can I put on my application. So perhaps if I can turn to Lady Rose, first of all, and looking specifically at what skills do solicitors have that could be used in an application for a judicial role. Can you give us, what do you think? What should they bring with them? What can they bring to the bench that they could work on or really highlight when they're making applications?
I think what they can bring to the bench, which the bench always needs, whichever bench you're thinking of applying for, is legal expertise and intellectual ability. And I think it always was a complete myth that you only found that at the bar. And I think it's now a growing recognition that there was always a myth, and that there is intellectual excellence and judicial skills in every branch of the profession, and at the employed bar, employed solicitors, as well as in private practice. I think that solicitors have a great deal of experience in solving difficult legal problems, which is what judges do day in and day out, and also in finding practical solutions to resolve disputes, to try and work out what it is the client or the parties need or want to get from their interaction with the legal sector, and trying to resolve that. I think that whether you're giving an extempore oral judgment or writing, as I do, a great long screed, judgment writing is an essential, obviously, part of the role, and the judgments are directed at the parties. They're not directed at the solicitors or the barristers. And I think solicitors also bring that aspect of their work, which is their more direct interaction with the lay client and their experience of explaining complicated legal issues to lay people, and understanding what they want, and being explaining to them the reasons for the decision that they are taking, explaining to them the process that the court is going to go through, what their role is going to be, what's likely to happen. And I think that that's a very useful skill to have. I think that solicitors who have worked in contentious business also have a deep understanding of the court's processes, And that's also a very useful skill to be able to bring to the bench. And I hope that more solicitors will take that step, because it really is a wonderful job. I mean, I regard it still as an honour and a privilege, and it's a fascinating career. And I think that if you are interested in the law, not necessarily academically, but as a way that people are facilitated to do what they want to do, and as the law binds us all together in society, then you really should think about the judicial career, because it is a very interesting and practical way to use the judicial skills that you've built up over the years.
I think that's a great tip, actually, Lady Rose, because you're absolutely right. We sometimes forget that actually, although we're not giving a judgment to somebody, we are giving one side of the story to somebody and explaining to them in a step-by-step process, whether that's in writing or orally. You are setting setting out your stall. So I think great advice that we should look to gather those examples and use them when making applications. So let me turn to Jane now, because you obviously see the applications from the other side, and you have done, and you mentioned that when you opened a little bit earlier. Perhaps you can give us an indication as to what kind of transferable skills do the actual JAC look for when they are looking at applications, and what's in those applications?
Yes, thanks. And it's such an important issue, this, and the emphasis should be on transferable, I think, because one of the problems is that many solicitors don't have court-based experience, and that often trips them up in the application process, and it doesn't need to. That would be my main advice, and I'll come later on in the session about preparation. But the JAC for the entry-level roles, by which I mean roles below the High Court, both fee paid and salaried roles, basically uses what are known as competencies, and there are 5. And competencies is just a sort of modern word for that combination of skill and knowledge and ability to do something with the skill and the knowledge. And there are 5, and they're exercising judgment, possessing and building knowledge, assimilating and clarifying information, working and communicating with others, and managing work efficiently. And in the interest of time, I won't try and go through all those 5, because I could be here for quite a long time. But if we pick 3, and none of them are more important than the other, that's a really important thing to say. I think quite often judicial members who join us on panels think, well, obviously exercising judgment is the most important thing. And the lay people quite often think the most important thing is working and communicating with others. So, and none of them are scored more highly than the other. It is that collection of competencies that makes the person capable of being the judge, regarded as appointable. But if I just take exercising judgment, possessing and building knowledge, and possibly, yes, and working, managing work efficiently, because I think they're ones where the solicitor will have very good evidence. And evidence is a really important word. We don't look for general statements of commitment. I would make a slight joke. Quite often I've read applications where people say, I've been committed to justice and the rule of law since I was 10. A little bit like Judge Mulready's story, but the story was a very effective story about what motivated her. In an application, that's fine, tell us that, but you've got limited words, and what we need is evidence of what you mean. So, exercising judgment, you probably won't be able to tell us about an occasion when you have had to come to a difficult judgment, write it up and tell people what your decision is. You may have if you've been a trustee or a governor of a school, and use those examples if you've got them. Again, people sometimes think they can't use examples outside of the law. You can. So if you've got an example where you've had to make a judgment. A disciplinary matter, as I say, a trustee issue, sacking somebody. There are all sorts of difficult decisions we make in life. But there are under each of those competencies, and you'll find them easily on the website of the JAC. There are little descriptions underneath of examples, and underneath exercising judgment, one of the important ones is demonstrating independence of mind. And another one is ensuring fairness, demonstrating integrity, acting without bias and prejudice. Now, this is bread and butter, isn't it, to any lawyer? And so what I would encourage solicitors to think about is, how can you demonstrate that you had to show your independence? It may have been an issue in your firm that you were concerned about. It may have been an integrity issue where you felt people weren't behaving properly, that you had to take action and challenge. There are all sorts of examples that you can use that would be able to show your ability to exercise judgment. Possessing and building knowledge. This is about showing that you are able to keep up to date with the law. How do you do that? And how do you particularly tackle something where it's not your familiar area of practice? So you've had to start, not from scratch necessarily, you'll know the first principles, but you had to sit down and read the law about a particular issue or how it applied in a particular case. So how did you do that, and how do you routinely keep up to date? Don't wait till you're in the interview and you're asked that question and you think, well, what did I last read? How do I keep up to date? Think about how you do that, how you keep abreast of changes in the law. One of our questions to the most senior applicants is, tell us about a case in the Supreme Court or the Court of Appeal, recent case, not in your field, that you think has been important. And remember, I'm a layperson, so could you explain to me in 3 sentences what it was about in layperson's language? Well, that's quite a good test to ask yourself, as a lawyer. You read the Times law reports, you read, the much more professional law reports. How would you explain that to your mum? How would you explain that to your neighbour? Think about that, and that will help you demonstrate possessing and building knowledge. And then managing work efficiently. I chose that one because it's one of the competencies that stumps barristers. They often say to me, well, I work really hard, my diary is really busy. It's sort of, they don't think about, well, how do I manage? And it's very interesting that it's solicitors who mention the word prioritise. It isn't barristers. Barristers just talk about working very long hours all weekend, which I'm not suggesting they don't. They do. I know they do. But how do you manage your time when you've got conflicting demands? What do you do? Do you turn to others to help? How do you work with a team in those circumstances? How do you manage the conflict? How do you prioritize? And also resilience, a really useful word to think about. When you're under pressure, how do you cope? How do you manage the demands in those very, very demanding, pressurized situations? And I think solicitors often have much better experience of that because you're having to work as part of a team in a way that often barristers don't. So those were just 3 examples, I thought. But the main point is that I would say is you're not. One of the mistakes, and we'll come back to this in a minute, one of the mistakes people make is to think that they're demonstrating how good they are at their current job. You're not applying to be a solicitor, you're applying to be a judge. So we're not expecting you to be able to prove that you've been a judge, because you haven't been, but we are expecting you to provide evidence of how you would make the transfer to being a judge. And being good at what you do now is only the starting point. It's thinking about, how would I use what I've learned from being a solicitor over the last 10 years so that I can show that I would be capable of being that judge.
Thank you very much, Jane. That kind of takes us nice and seamlessly into another question that hopefully Judge Mulready will be able to help us with. How did you look at, you know, transferable skills and use those in helping you to succeed with your judicial career. What did you pick out from your career? How did you use what you were doing on a day-to-day basis in another role to kind of show that you could do a judicial role?
Thank you. I got some really good advice from a more senior judge just before I did my first application, and I was kind of terrified. And she said, look, you've got 3 children. Being a good judge, running a successful court hearing is like taking young rowdy children on a long car journey. I don't know why she thought I would relate to anything about young rowdy children, but anyway. And she said, you know, you've got to be prepared, you've got to think of everything, you've got to try and head off conflict, manage high emotion, anticipate what might go wrong, have a plan for how you're going to deal with it, have a plan B for when your plan A goes wrong. And that is really, you know, that's really good advice. And I still think about that often. I think having 3 children really helps me to be able to handle court. Particularly in proceedings where, you know, the applicants and maybe their families are really struggling, the stakes are very high. You know, in the special educational needs court, it's about whether their children are going to actually have the access to education that the family feel that they need. And, you know, they might not understand procedural rules, that they're only allowed to speak when it's their turn and so on. But you have to balance, you know, the real empathy you feel with that against the need to give both sides a fair trial, keep your hearings to time, and get the information you need to make your decision. So I think it's not just, you know, our professional lives that give us relevant skills, it's also sometimes our personal lives. I think as solicitors, we're also maybe less than barristers, used to reading a huge amount of material, at least some of it not remotely relevant to our client's case. You know, we like filter out stuff that might feel important to the client but doesn't actually, you know, isn't really on point for their case. And we're used to teasing out what's relevant and then remembering what you need, leaving behind what you don't. And that's a really useful skill in judge life as well, because there is so much reading to do. By way of example, I haven't started my preparation for court tomorrow because I've been in court all day and now I'm here. And the papers have probably only just come online in the last hour or 2. And I could easily have 800 pages to get through this evening before I'm in court tomorrow at 10. So my speed reading skills that I learnt from my solicitor days, they really, really do help me now. And then I've just got a couple more points. One, again, is about my kind of personal experience. And as Jane mentioned, less in-court experience than barristers have should really not be a barrier to a judicial career. And I think we've all got aspects of our personal lives which are useful in a judicial career. And that's another reason that a diverse judiciary is a genuine strength. You know, it's not an act of charity, it's an act of, you know, making us excellent. And for me, one of those aspects is that I had my oldest child when I was a teenager, and then I spent some time living on benefits. And, you know, that has helped me a lot because I can remember what it's like to be dismissed as not credible, as not as interesting or informed as everyone else. And we all know, you know, unconscious bias is a real thing, even in good people. And I'm by no means saying that judges must all have this kind of life experience in order to be great judges. Of course not. But I think that personal insight and experience, it helps me in the way I communicate in courts. You know, and it's obviously more relevant to some people and less relevant to others. And then the final point I'd make is about multitasking and the ability to stay authoritative in circumstances which are sometimes less than ideal. So just by way of example, today I've been hearing bail applications all day by telephone, and the people in detention are joining by telephone. I'm here on the telephone, all the different representatives and witnesses and everybody is joining by telephone, so I can't see who's there. I need everyone to talk to tell me who's there. So I'm managing that. I'm checking everyone has the papers. Often they haven't got all the right papers. I'm then sending them out by email on my computer whilst I have the telephone call in my headphones. There are technical difficulties. The call cuts out all the time. I have to manage that. I have to manage interpreters. And in the mix, there often is someone who's quite distressed. And they often don't have legal representation, so I have to help them to explain their case. So there is a huge amount to do that is quite far from understanding and applying the law. Obviously, this will be more and less relevant depending on what court you're sitting in. I can imagine, quite rightly, Lady Rose doesn't have to manage malfunctioning conference system. But keeping cool under pressure, you know, and you've got so many other things that maybe you wouldn't expect to be part of judge life, being able to do that, I think is useful, and something that, you know, I think I'm better able to do because I've had my solicitor days.
Absolutely.
Thank you. I love the analogy with children. I mean, how many people will be on this call that can relate to some of that? It's a great analogy, I think. So just going on to thinking about preparation, and, you know, if you want to put in an application, you've got to think about, right, how am I going to prepare for this application? And actually, I know we've not got to the Q&A yet, but we've had a question come in on the chat already, asking about coaching or guidance that might be available. So perhaps if I turn to you, Jane, and I don't know if you can help us, but you know, what preparation opportunities are available for those that are thinking of applying for a judicial role, so that they can start addressing their mind to, you know, what do I need to prepare? How do I need to do it?
Yeah, well, there are lots, actually. And I mean, the very first thing I'd say is self-preparation. I have been a bit shocked over the years in meeting candidates who've never looked at the JAC website. And the first time that they've thought about a judicial application is a few days before the closing date for the role for which they wish to apply. And I have to say, it's a bit like the, you know, never mind mother and children, the athletes say, don't they? Fail to prepare, prepare to fail. And that is the reality. If you do not invest in the preparation to make an application, then the likelihood of you fulfilling your own prophecy of not being successful is extremely high. So spend some time, if you haven't done already, after this event, spend some time going through the website, because there is lots on it that will help you. There are tests that you can, you know, mock tests that you can do. There's lots of information. There is an available document which is a little bit hidden at the moment. It's not deliberately hidden, but not as easily available, which I will make sure Stephen and Danielle on this call have, that could be sent to everyone who registered, because it's a very useful document. But there are lots of things that are, you can sign up for something called Judging My Future, which is about future applications and what you need to do to prepare. As I say, there are mock tests. There are there's all sorts of information available that will help you think about it. That's point one. Second point would be, start now. If you're serious that you think you might want to be a judge in 5 years' time, if you're, you know, a more junior member, or in a year's time if you're more you know, nearer to being ready, have a folder. It might be a paper folder, it might be an electronic folder, into which you put things that you've done and you think, oh yes, that would be a really good example for when I'm making an application. Because the problem is, when you sit down to write it, you forget all the things you've done, or you don't remember the most useful things you've done, or the most colourful. And certainly when you sit in the interview and I ask you a question about, tell us about a time when you had to show independence of mind, your mind goes completely blank. So don't wait to think about examples then. Have them ready in a folder that you can then draw on in both written application and in the interview. So they're things that you can, I mean, there are lots of others. You can sign up to do what are known as dry runs. I mean, those of you who've been candidates previously will know that all our applications entail some kind of exercise. It could be a role play, it could be situational questions, it could be judgment tests, and we test them in order to make sure that what we think we're asking is what candidates understand when they're put in the situation. We test them and we ask people to act as volunteer dry runners, as we call them. And obviously you can't then be an applicant for that particular exercise, but it doesn't stop you being an applicant for future exercises in that same kind of role. So recorder exercise, it's always a role play. If you want to find out whether you're good role play, because some of us hate it. I mean, I've never enjoyed role play. Some people love it, but either way, you can volunteer to do that, and it's a really good way, because what happens in return for you giving us your time, you get very good feedback from the judicial member of the panel, which is really useful for you for the future. So that's another judicial work shadowing scheme, which I think Judicial Office help to arrange. But I mean, Judge Mulready, sorry, I don't actually know your first name, Judge Mulready. I keep referring to you that way.
That's right, Molly.
Molly,
Yeah.
as Molly mentioned, she got really good help from an experienced judge, and I think that is one of the best ways. So, and if you don't know how to go about that, there's advice that you can tap into, and we, the JAC, publish opportunities to engage with judges to get that kind of experience. And then there are a couple of formal things. There's the pre-application judicial education programme, which is particularly aimed at helping people who have less experience from disadvantaged groups and so on, underrepresented groups, which is a formal programme. And there's also other ways, targeted outreach, where we link candidates with experienced both judicial people and former commissioners from the JAC. So there's a really wide range of opportunities, all of which are referred to on the website, which give people, and we target, in particular, we are putting our resources into people who are less well represented in the judiciary at the moment. So solicitors, women and ethnic minority candidates, because we know, as you said earlier, that is what will help us increase the diversity of the judiciary, which we're very committed to doing over the coming years, and have made strides already. By comparison, as Lady Rose referred to at the beginning, with the focus on the bar, which of course 20-30 years ago mainly meant white middle-class men, and now no longer does mean that. The people coming into the judiciary are virtually half and half, men and women. We've still got a long way to go in terms of ethnic minority representation, but so those are the things that I would say. It's both a personal commitment to thinking, this is what I would like to do in a future date, and that future might be quite a long way off, or it might be relatively soon. But the main point I would say is really give some thought to investing in yourself in preparing for that.
Thank you very much. So if I can turn to Judge Mulready, what sort of advice would you give to somebody who is about to take the qualifying test or thinking of taking the qualifying test? And I don't know if you can tell us a little bit about how you approached it when you were doing it, and what tips you can give for that in terms of preparation.
Mm-hmm. I mean, again, I got good advice myself before I took the test from more senior judges. The first thing I'd say, this advice is advice we've no doubt all been getting since we were, in school, but read the question. It's so basic, but it really bears repeating. Secondly, do the practice tests. I mean, the Judicial Appointments Commission, it really does bend over backwards to give you as much information about what's going to happen to you. So you know what you're going into with your eyes open. There are practice tests. I think they're on the JAC website, and I did them with a stopwatch beside me. I think there are two different categories of question in the test. Yes. And if you try and notice, does one type of question take you longer than the other? And if so, you might want to adjust your pacing for the real thing, so you have more time for the harder ones, less time for the easier ones, and so on. And I go very detailed on this, and I literally write out the time that I'm going to start each question and the time I'm going to finish, even if it's like 3 minutes, and I go, and I tick them off. And when I do the real test, I do that with a stopwatch in front of me as well to make sure that I don't lose time. I mean, for me, running out of time is the greatest problem. So that's why I'm kind of try and be fastidious about it.
It is for most people, Molly.
Yeah, okay. So no, not alone.
No.
And I mean, very similar to what Jane said, find a judicial mentor. There's a judicial mentoring scheme, which is all about underrepresented groups, people from ethnic minority backgrounds, and also socioeconomic diversity. So looking at people who've gone to state school, like me, people who are the first in their families to go to university. You know, there are mentoring schemes targeted at those people as well. Find them and get yourself a mentor, because then you have your own personal backup through the whole process, and it really is invaluable. And finally, reasonable adjustments. I'm sure it says this on the form, but if you need them, ask for them. They're your right. You won't be penalised for asking for them. So, you know, do it. And I think it's really important that everybody uses reasonable adjustments. You just make it easier for the other people who need them and who'll come after you to make use of them. So yeah, I'd say be proactive and alert on that front as well, and ask for what you need.
Yeah, good point.
Fabulous. Yeah, great. Thank you very much. So Lady Rose, you managed to make this transition from a lawyer to judge, and now, you know, one of the most senior judges in the country. How did you do that? How did you prepare to do that?
Well, it was a very deliberate decision, as I said in my introductory remarks. When it became possible for government lawyers to apply for judicial posts, I was a grade 5 lawyer in the Ministry of Defence in a purely advisory capacity, and I recognised that that wasn't a great jumping off point if I ultimately wanted to apply for the High Court bench. So it took me 8 years of quite deliberate career planning to get myself into a position where I would be able to make that application. Like almost every judge, I started out in a fee-paid role, and almost every position, whether it's in the court judiciary or in the tribunal judiciary, there's a cadre of salaried judges, but there's also usually a much larger group of fee-paid judges who just sit for 5-6 weeks a year. And that helps people who are thinking of a judicial career to have that experience, see if they enjoy it, see if they're any good at it, without sort of burning all their boats by having to jump straight into a salaried role. And also, like a lot of judges, I started out in a tribunal post in an area of the law which I knew something about. So I had been a competition law specialist when I was at the bar, and there is the Competition Appeal Tribunal. So for me, it was a matter of updating my expertise in that and then applying for that judicial post. And then once you've got some experience in an area which you know something about, then, as I did, you can jump across, and I also became a fee-paid judge on the Charity Tribunal, on the Environment Tribunal. I then made the big jump to be a recorder in the Crown Court, which is a part-time judge sitting in jury trials. And that was a big leap because I'd never done any criminal work before. What I did in that time, there wasn't quite so much official mentoring, but there are a lot of private companies which do interview practice and advice on form filling. When I applied to be a recorder, I did go to one of these advisory companies, and I had a kind of mock interview, and I found that very helpful. It was not exactly frowned upon, but it was quite an unusual thing to do in those days. But I thought, I really want this. I don't want to leave any stone unturned. If I don't get it, I don't want to think, oh, well, if only I had gone to them. And I did find it very helpful. And also when I applied for the High Court, I also had a similar experience. And I found their names in the back of, I don't know, Council magazine, or I'm sure Law Society magazine probably includes the same sort of adverts. I was also fortunate that I had a lot of support from the government legal service, and they were very helpful because they regarded it as a very positive thing. And my sense is that whilst the Government Legal Service has that approach, and also barristers' chambers do, I'm not sure that the big solicitors' firms or small solicitors' firms have the same positive approach to adopting a policy which enables people, whether they're already partners or whether they are thinking of becoming partners, also to be exploring the possibility of a judicial career by taking a fee-paid role. And I think it would really help. This is partly directed at you, Lubna, as well as to anyone in our audience who might be have this in mind. I think it would be a big help if solicitors' firms did publish their policy on this and encourage people, because I think there is a feather in the cap of solicitors' firms if their people become part-time judges and go on to be full-time judges. So that's what I did. I absolutely agree with what Jane said about looking at the competencies, thinking, well, what would I say now if I had to give an example? And if I don't have an example to hand, what can I do between now and when I'm going to be ready to apply? So, for example, if your practice is entirely big money commercial M&A work, say, you might struggle with what is an example that you can give of an awareness of all the different groups there are in society that will use court services. So if you don't have that opportunity in your work, then you can explore other aspects of your life that will give you something that you can say. So I make no secret of the fact that I was ambitious. I did plan my career quite carefully so that I would be in the position that I wanted to be able, 8 years on from it being possible, to apply for the High Court.
Thank you very much. Thank you, Lady Rose. I mean, we're not going to the Q&A yet, but there are some themes that are coming out in some of the questions in the chat, and some of the things that perhaps we can talk about more generally. Jane, if I can turn to you, because obviously you're one of the people that sees these applications when they land on your desk, and you see what is actually written in there. And one of the questions that I've picked up in the chat is asking about, how do we get feedback at the initial stages of sifting? How do we deal with that? So perhaps you can help us with telling us a little bit about, there must be some common mistakes that you see when you're reviewing applications, things that, you can say right now, do not do this. Can you share some of that with us for people to take away?
Yes, I mean, a mix of don'ts and do's, really. And the first thing, I mean, it relates to my earlier point about don't leave it till the night before the closing date. You wouldn't prepare, any of you, for a big case, whatever the case is, and a critical deadline by waiting till the weekend before the event and then spending 24 hours working out. I mean, sometimes we all have to do that. That happens. And Molly was talking about, she's going to have a long evening or a very early morning for tomorrow. So don't wait till the last minute. And the biggest mistake people make is to set out to fill in the form online at the last minute. And we don't set the word count because the form isn't very long. We set the word count as part of the test. So the idea is that you're asked to give your evidence succinctly within a limited number of words. And I can't tell you how many people ignore that. And the fact is, the people reading your form only see up to the word count. So anything you write after that doesn't get read. So top advice would be don't write on the form, write in a Word document, and then when you're happy with it, cut and paste it into the form. Always get a really critical friend, the person whose judgment you probably dread, really, in other way of life, to read your form and tell you how rubbish it is. Because that will make it so much better. Don't ask your mum or your best friend who will be kind. Ask somebody who's going to give you quite critical feedback about it, and who will also say to you, well, don't you think that case that you worked on that was really difficult would be a better example than that one? Someone who knows your work. Think about who your independent assessors are going to be as well, along the same lines, because again, candidates quite often only let their independent assessors know at the last minute and haven't shared information with them. There's nothing wrong with you sending examples, sending your own application form, but sending examples to your IAs saying these are the things, these are the cases that I've cited in my application. When you're asked for the independent assessment, you might want this background information, because we look for evidence from assessors. We don't just look for testimonials, we look for real evidence of the skills. So really spending time on honing your application is the most, because that's the first stage. That, well, sometimes the first stage is the online test and then the written application. Sometimes they run in parallel. It depends on the numbers of applicants we expect to get. Preparing for the situational judgment test and the comprehension test that Molly was referring to, that is an important part of it. And if you really hate those kind of things, then the more you can do, the better. And there are examples on the website, and you can use them to test. At the moment, I think it's still the case that we don't tell you the answers. Now, that's something that we've had quite a lot of discussion about internally. Personally, my view is we should give, if we're going to give you a mock test, you ought to be able to turn to the back and find out what the answers were. And the reason at the moment is because of the style of questions we use. We don't do that, but I think it's something that will change. But there are other similar tests elsewhere in life that you can use that will give you the kind of experience of doing those sorts of tests under pressure. And Molly's example, because people do run out of time very frequently. So using your stopwatch to time yourself is really important. So what are the other mistakes that people make? It is the generalizations. My comment earlier about saying, you know, I've been committed to justice since I was 10. What we really want to know is how you have exercised your skills in and use there's an acronym SOAR, SOAR. So what was the situation? What was your objective? What action did you take and what was the result? So that's a quick way of thinking about the example. So what was it that you were challenged with? What were you trying to achieve? What did you do, and what was the outcome? And wherever you can, and this is particularly directed at the women in the audience, talk about I. Men talk about I very naturally and very easily. Many more women talk about we, and it's a difference to do with how we're socialized many times, that women talk about team and joint effort. This isn't a time to be modest. It's not a time to tell lies, but it's not a time to be modest. We want to know what you have done and how you have achieved in your role. So think about I examples all the time in order to demonstrate your ability. There are some examples on the website of self-assessments, which is a key document that where you're expected to write your evidence of your ability to meet the competencies. So do look at those and look at the advice, the best examples that you can come up with. You don't have to write flowing prose. Bullet points are fine as long as they're explicable to the audience. And do stick to the word count. You know, really big mistake that people make is to run over. What else? I mean, yes, print it out. I mean, this is an old-fashioned woman who, you know, was used to writing papers. And when I say writing, I mean writing. But it is interesting. Even young people spot errors more on paper than they do on screen. So even though you've grown up with doing all your work on screen, it does pay dividends to print out, read and think, well, that actually doesn't make sense now I've read it quietly. I need to twist that around and edit it down to make more sense. So that would be my other bit of advice. The exercises are very competitive. They may be competitive against a standard, or they may be competitive against a standard and other people. And that depends on the number of applicants and how many meet the merit level. So you may find yourself perfectly appointable, quite a strong candidate, but unsuccessful this time round because there are fewer places and there were more people who were meritorious. That's really hard. It's really tough being told, well, you were appointable, but sorry, someone else or several other people beat you. I've been in that position in the civil service, you know. Oh yes, Jane, we thought you were appointable, but actually there was somebody we thought was better. In some ways, that's harder than being told you weren't suitable. So it is tough, that. But the other thing that we've learned from the stats is we provide individual feedback in the more senior, smaller roles, and general reports of feedback on the very large roles. I mean, 2,500 applicants to be recorders. We can't possibly give everyone individual feedback, but the feedback reports provide the common features of successful candidates and the common features of unsuccessful candidates. And what we found is that candidates who have previously read, who've applied and been unsuccessful, but have read the feedback and really used it, are much more likely to be successful next time round. So again, it comes back to the preparation point. So do have a look at those feedback reports because they will help you make a more successful application next time.
And just one very quick question, Jane, that I think you'll probably be able to knock off straight away. Somebody's just asking, can you refer to kind of experience from more than 10 years ago? Is there a time limit on the sort of experience that you're looking for?
There's no time limit. I think we generally ask candidates to provide evidence from recent evidence from the last 2 or 3 years. But if you've got a really good example from 5-10 years ago, don't feel you can't use that, but do recognise that you also need to think about how you can demonstrate up-to-date experience. One of the things we have said to panel members is if you ask a candidate for an example and they give one from 10 years ago and you don't say to them, can we have a more recent example, you cannot mark them down because they didn't give you a recent one, because you asked them the open question and they may think their best example is 10 years old. But so it's a mix. Use your judgment, I would say. If the most high profile case, you know, the one you're known for is the Birmingham 6, well, it's very old, but think about how you would demonstrate that remains current. What is it from it that you learned, that you brought into your practice? So don't just rest on the laurels of that particular case, if that makes sense.
Thank you. Yeah, that's really helpful. Thank you. I don't know whether to call you Molly or Judge Mulready. I'm sort of
Molly, definitely Molly.
Okay, great. Thanks, Molly. So you've made this switch from being a solicitor to becoming a judge, and you've talked about, you know, some of the challenges. Actually, some of the challenges that you were dealing with in your life anyway. But when it comes to just making that switch as a career, how did you kind of get over some of the challenges that lay ahead?
Mm-hmm. I think it was all about preparation, like any new job, you know, getting to grips with all the training materials, knowing where to find things, conquering the IT and the different ways of saving things, you know, working out your own system so you can find documents easily and not have to reinvent the wheel every time you have to write another judgment. I think, like many other judges I've come across in tribunals, I had very little experience in the areas of law in which I found myself working. So it was a steep learning curve, and it was important for me to know who to turn to for support. So I'd make a point of saving the phone numbers of people I came across who, I mean, were willing to give me their phone numbers and who I thought would be, you know, useful in due course, whether they could help with questions about the law or give me moral support, be willing to be a sounding board, or, you know, a potential friend. They're useful too, you know, friends within your judge world, because you can find yourself in a role where you're the only judge, you know, you're not on a panel, the decision is yours only. But I think for me, and I was thinking about this last night, preparing for this, the most significant point, I think, was making the adjustment from being someone who's in the business of persuading to someone who's in the business of deciding, and getting into the right headspace to kind of own the risks of my decisions, you know, own the risks of having that power, if you like. If I get it wrong, there can be serious consequences and you can't get away from that. Someone who has a need for asylum, if I get it wrong, they might be sent back and face persecution, or I could release someone detained under the Mental Health Act and then they could come to some harm, or they could cause someone some harm, and so on. And then there's the exposing feeling that my decisions are subject to the possibility of an appeal. So a more senior judge can do a kind of very public marking of my homework and set out all the many and varied ways in which I've got it wrong. So I suppose it's about making that mental adjustment into a very different kind of responsibility, being aware it's a transition, it takes time, and there's good comradely support available for that from judicial peers, and that's really been invaluable to me. And so I think as people are completing their forms and going through the process of judicial application, this isn't the kind of nuts and bolts, really valuable nuts and bolts information that Jane has been given, but it's more about the mood music around your application. You know, if you're aware that's the professional transition ahead of you, that will come through to those considering your application and will give them, you know, a sense that you're confident, hopefully, and aware and ready. So I think it's important.
Thank you very much. Lady Rose, you've been very successful in moving from one judicial role to another judicial role throughout your career. And I can see that somebody's posted a question asking about advice that you might be able to give to somebody who's moving from a fee-paid role and might want another role. And, you know, what's the procedure? Do you have to go through the full application process all over again? Perhaps just if you can share with us some of the lessons that you've learned when you've been trying to transition through different judicial roles during your career.
One of the lessons I've learned, and listening to Molly, I think she's learned this too, is that a lot of legal skill is actually generic and it's not at all linked to the topic that you have had your practice in. And I think I had the advantage in a way coming from the government legal service, because the service really does recognise that. And every 4 or 5 years, you move to a different department, you pick up a completely different portfolio, completely different area of the law. So I had examples that I could give when asked the question, you know, how can you show that you can quickly pick up a new area of the law? And I felt more confident about that than perhaps someone who spent 30 years in the pensions department or the employment department of a firm, or has only done a particular kind of work. So, but one of the lessons I learned moving from the Competition Appeal Tribunal into other tribunals, and then to be a recorder in the Crown Court and then in the Chancery Division, and certainly now where we deal with every legal topic under the sun, is to have confidence in my ability that if you have the skills that Molly was describing of absorbing information, sorting out what's relevant, what's not relevant, of reading statutes, of reading authorities, of being able to see where they fit in and where the principles lie, that is a set of skills that you can apply to any topic. So I would say, don't be put off by the thought that well, all I've ever done in my practice is X kind of law. How would I possibly cope if I was in some other, I have to deal with some other area? There is a lot of training available as far as the legal topic is concerned, but what I'm sure Jane would say is that what you're looking at is judicial skills, and those are not dependent on the particular topic that you've got. I think one of the other things that I learned, which was I wasn't entirely expecting, I mean, when I went into the judiciary, particularly when I became a High Court judge, I didn't really know anybody because I had not been a senior barrister. I'd come from the government legal service, I'd come from the tribunal judiciary, both of which were sort of on the not the mainstream, and I wasn't quite sure how I would get on with everyone. But one of the wonderful and surprising things I learned is actually how great all my colleagues have been, right from when I was working in the CAT throughout the tribunal work and in the various Crown courts where I sat as a recorder, and then certainly in the High Court and the Court of Appeal. And now there's a huge camaraderie amongst the judiciary, which is very supportive. It's always been a very non-bitchy environment, if I can say that. And I have friends who work, in all sorts of walks of life, in offices where everyone's kind of, horrible to each other, and there's a lot of kind of politics and that. And I've not encountered that at all. And that's been one of the real, perhaps unexpected pleasures of the job. To have really wonderful and supportive colleagues who are always open door to help you if you feel you've got yourself into a bit of a pickle, with practical advice. So I'd say those were the two big lessons that I've learned.
Great, thank you so much. Well, I think we've exhausted all of your pearls of wisdom, so I think we're going to try and use a few minutes to go through a bit of some of the. I mean, in fact, we've answered quite a number of the questions as we've gone along during the webinar. So let me see if I can pick up a few that perhaps we haven't got answers for yet. One question was, are you allowed to have notes in the interview if you get to interview stage? Very straightforward question. Jane, perhaps you're the best one to deal with that.
Yes, you are. You're more than welcome to bring your own personal statement with you and refer to that if you wish to, because the questions that you'll be asked fall into the competence areas, and your statement falls into the competence areas. Yes, you can bring notes, and we will ask you lots and lots of the questions are, can you tell us about a time when you had to, and people sometimes find that quite strange. And the other thing is that quite often lawyers have not had an interview for a very long time. Quite a lot of people have said to me, the last time I was interviewed was for a pupillage, or the last time I was interviewed was for a place at my law firm. And since then, promotion happens by a different process. It's not usually that kind of interview process. So if you're rusty, then definitely get some practice. But yes, bring notes. But don't make the mistake that one candidate made for me during lockdown when we were interviewing online, and she did this all through the interview. So I kept saying to her, would you mind dropping your notes down? But she was literally reading the notes she'd made, which didn't make a good interview. I mean, it wasn't good content. So it wasn't that the notes got in the way of it, but use your common sense. You wouldn't stand in court or in a meeting with a client hiding behind your laptop screen or your notes. So use them, but use them as a prompt, not as a script.
Yeah, thank you very much. And we have a question. This may be you again, Jane. I'm sorry, there seem to be quite questions that probably you're going to be able to deal with. And we're being asked about procedure in relation to holding a fee-paid role and then wanting another fee-paid role. Is it a question of going through the whole process from the beginning again if you're applying for a new judicial role?
Yes, usually it is. I can't think of an example where we give anybody a sort of buy from one role to another, because of course they're all competitive, so that there will be other candidates who you've got to demonstrate your ability by comparison with. There are some times we run exercises in parallel. So for tribunal roles, we quite often run common roles tribunal. For recorder, they're not usually jurisdictional. We're not, the JAC and our panel members are not equipped to judge technical legal expertise. We have a judicial member always on all our panels, but even they're not there to assess your legal expertise. It is your ability to be a judge, to exercise judgment. We're rarely asked to do jurisdictional roles. Deployment into, and I know there was a question about that earlier, so let's just say you apply to be a recorder and you want to be a criminal recorder.
Yes.
The deployment will be for judicial office, not for the JAC. We produce a merit list. We know that there are X vacancies in civil, family, in crime, and so we will ask candidates to say whether they have a preference, but that doesn't form part of the judgment that we make. That's information for judicial office when it comes to the merit list. And we do find, not unusually in those sorts of exercises, that we often have more candidates for some roles and fewer places, and fewer candidates and more places. That can be the sad thing, that there can end up with vacancies because we haven't had good enough candidates for those particular jurisdictions, if that makes sense.
Yeah, thank you. And somebody just asked a question about if you want to apply for district judge, you need to have 5 years post-qualified experience. Am I right in thinking there's no discretion on that? You have to have that in order, because it's an eligibility criteria, isn't it?
It's
you
an
have
eligibility.
to have 5 years PQE in order to be eligible.
Some eligibility is set out in law, and some of it is set by the Lord Chancellor or whoever is the responsible authority. It isn't a JAC decision at all. We simply apply the post-qualifying or the previous judicial experience criteria, and what we then have to do is, sometimes it's not easily determined, it's not simply a 5-year or a 7-year or whatever qualification. There may be other ways of assessing that, so sometimes we have to go through an eligibility discussion, and there are some roles that are accepted as providing previous judicial experience, coroners being an obvious one, but chairing, as a lawyer, chairing certain tribunals can provide you with previous judicial experience. But the main point I'm making is that it's either set out in law or it's determined as part of the eligibility for that particular recruitment exercise, and it's not always the same. So always read, again, Molly's advice, read, because we do get applicants who are not eligible, who've wasted their time, which is very sad, that they've spent time applying for something that on paper it's very clear they're not eligible for.
Great, thank you very much. Somebody's posted a question asking about whether you can evidence judicial skills and competencies in different roles, such as being a trustee, governor of a school. I think we've already answered that earlier in the session. It was very clear that you absolutely
I'd really
can.
encourage people
absolutely
to use
can. So that's the answer. If you've got other roles, you absolutely can. So perhaps if I ask, there was another question that came in. I don't know if Lady Rose or Molly might be able to answer this one. The question was around, is it possible to specialise in an area of law as a judge? And I suppose, if you're an immigration judge, you kind of are specialising in immigration, but I don't know if one of you would like to come in on that one. Lady Rose, would you like to come in first?
Yes, I think that's one of the big differences between the tribunal judiciary and the courts judiciary. Although there are areas in the courts judiciary, family law, for example, or being a Crown Court judge in the criminal jurisdiction, where both as a fee-paid judge and as a salaried judge, you will do a particular topic. But in the tribunal service, those are pretty much focused on on one area of law, and you will usually sit as the judge, and there may be lay people sitting with you who have particular expertise. So, for example, in the Competition Appeal Tribunal, I sat with 2 lay members, and they were professional economists or people who had successful careers in business or in telecoms or something like that. So that's if your practice has been in an area where there is a tribunal, that may well be a good starting point for you, and from then you can jump off into other areas. But there are other more general court judicial roles, as district judge, for example, or as a deputy high court judge, where you will have a broader range of cases. So you may straight away be playing a judicial role in an area of law that you're not familiar with, but you will have training and assistance with that.
Thank you. We're getting so many questions coming through and we're going to run out of time now as it started to get very busy. Another question we get, how do you prepare for role play? Any thoughts on that, anybody? How do you prepare for role play in the interview? And we've got a few questions relating to the interview process. We're being asked, how does the interview relate to the application form? Are you just being asked to expand on examples in your application form, or are you being asked to give different examples? Do you get multiple questions? Do you just get one or two questions and get asked to give a judgment? So it's clearly the actual practical process that people are interested in.
Yes.
Jane, I think might be back to you. I'm sorry, Molly, I'll come to you in a moment.
No,
but
it's
Jane.
why I'm here. It's why I'm here. On the first question was, how do you prepare for role play? I mean, one way would be to volunteer to be a dry runner. That's a really good way. But I think there are lots of situations where you could get colleagues to help you. When I was a senior civil servant, I used to have to appear before parliamentary select committees, and my team used to prepare me. So they would, I would turn up at the office unexpecting this, and they would say to me, we're doing a practice run, Jane, sit here. And the three of them would ask me, and they'd be much fiercer than a parliamentary committee ever was to me. Really helpful way of preparing. So get your colleagues to help you. And the role plays that you will be put into will never be expert. They will not be an area of law that any of you would be familiar with. They'll be invented situations where there is a dispute to be resolved, and you are the person being asked to resolve the dispute, and there will be two parties. That's all. Never more than two. Quite often a litigant in person type and a lawyer type. And they're in dispute and you're being asked to come to a decision. You're given the rules that you need to make the decision. So it's not, it isn't anything to do with depth of legal expertise. It is about managing a dispute and resolving it and coming to a decision and managing the time and managing bad behaviour. So that will be something that your colleagues could help you with. As far as the interview is concerned, there are no tricks. We really do not try and trip people up. We want people to perform at their best. The competencies that you're asked to comment on in your written statement are exactly those areas that you will be asked about. And each panel member will ask you about one or more of those. The judge is likely to be the person who will ask you about exercising judgment and possessing and building knowledge. The lay members will ask you about managing work efficiently, about working and communicating with others, and assimilating and clarifying information. So each of them will tell you what the area is they're asking you about, and then they will ask you probably a couple of questions each in each of those areas. There is only 40 minutes. So you can tell with 5 competencies, there'll be a bit of time for you to do something at the beginning and a bit of time for you to ask a question at the end. And in between, this is about those competencies. So if you can possibly think about some additional examples to the one you wrote in your form, because that'll be much more persuasive. If you use one example all the way through your form and your interview, they will naturally think you've only got one example, and you want to show a range. So as much as you possibly can, have something else that you can talk about.
Lovely. Thank you so much, Jen. I'm just really mindful of time because we've got 2 minutes, and I'm going to ask Molly in 1 minute, if you can, Molly, 2 questions. How far in advance are you given notice of sitting days? And that's somebody who's asking, who has an employed role and wants to know how they could juggle a job with sitting days. So how much notice do you get? And the second question, references. Is it okay to get references from somebody who doesn't have a senior position in a courtroom or doesn't have courtroom experience? So could it be an assessor in another field? So if you could answer that literally in 1 minute, that'll be brilliant.
Sitting day. So I'm salaried, so it's different if you're fee paid, but I get my itinerary for the forthcoming week usually on the Thursday before the previous week. So before you know, the Thursday before the week I'm going to be sitting in. When I was fee paid, the process in mental health and special educational needs was that I would email a month in advance, these are all the dates I'm available to sit on, and then usually they would fill them all up with sitting days. So that's That's that. I think it varies
Thank you.
from tribunal to tribunal. About the references,
yeah.
I think Jane can probably give more authoritative insights on that than me.
It's really
Quick,
helpful
yeah,
to
quick
have.
as you can, yeah.
Yes, of course. It's helpful to have one of your independent assessors be your line manager or someone who knows your work very directly from an employment situation if you're an employed solicitor. So someone who can talk very directly about your work. And then otherwise, it really helpful to have somebody who could talk about how you might be as a judge, and choose somebody who knows about your work. There are sometimes people think will be influenced by the seniority of the individual. So don't go away and think, oh, we'll ask Lady Rose because she was on that webinar. She met me. You know, I've seen Lady Hale, who's, you know, incredibly kind and very encouraging of young lawyers, is often asked to provide an IA because she sat next to somebody at dinner in court in the inn, you know, and the poor woman can't really talk about the person's work. So don't make that mistake. We're not influenced by who the IA, it's the content of it and the evidence they can provide about your work. That's what's persuasive, and it can make a real difference if, you know, there's a gap between the application you've written, and we're not quite convinced that you're sufficient or strong, and that can make the real difference if your IAs are saying, here's some really good examples from this candidate's work.
Thank you so much. I'm afraid we're out of time. I'm really sorry to those people who posted questions that we haven't been able to get round to. And thank you to whoever has been answering some of the questions as we've gone along. That's been really helpful. The recording is going to be available. We'll be sending out a link for you to watch it later. I just want to say a really huge thank you to all of our panelists. I have to say I've learnt lots just listening to all of you. Lady Rose, Tribunal Judge Molly Mulready, Jane Furness, all of you, honestly, all of your tips, your advice, wisdom, all been invaluable, and I'm sure many people have found it very useful on the line, and hopefully as a result of it we will see more solicitor judges being appointed,
please, which is
what we want. Can I just remind everybody who is on the webinar, we are going to be sending out a feedback questionnaire. Please do fill it in because we need to know, you know, what more we can do to support you and how you found the webinar so far. And can I also say, please do follow the Law Society and the Court Service. Supreme Court have got a website. HMCTS have got a website. They are all on. We're all on Twitter. We're on Instagram. We're on LinkedIn. We post updates on there. You'll get details of future events. You'll get details of jobs coming up. You'll get details of opportunities. Please do follow and have a look at those. So thank you again to our panelists. Thank you to everybody online, and good luck with your applications, everyone. Thank you so much. Bye-bye.
Thanks, Lubna, for managing it so well.
Yes, thank you very much.
Thank you.
Bye-bye.
Thank you.
Bye.
Bye.